Afternoon, everyone. Thank you for joining us. I'm Brad Cave. I'm a senior partner in Holland and Hart's Cheyenne, Wyoming office, and I'm joined by Mark Waletsky, who's a partner in the Boulder, Colorado office. Thanks for being a part of our webinar on the FTC's non-compete rule and the healthcare employer. During the webinar, you can ask questions using the chat function. You should see in the lower right-hand corner of your screen a chat balloon. And by clicking on that, you can type in your question, and we'll do our best to get to those either in the course of the presentation or perhaps at the very end. First of all, read that very quickly, like you hear at the end of advertisements, and we'll move right along to the substance of this. So you all know what we're talking about. The FTC issued its final rule on non-compete clauses on April 23rd. We knew this was coming. There had been a proposed rulemaking published in January of 2023, and the FTC had been receiving comments on this proposed rule for several months. They received over 26,000 comments, they reported, both in favor of the proposed rule and opposed to it. The Federal Trade Commission, some of you may be scratching your head and asking what they have to do with your employment relationships, and that's a great question. They have never had much to do with your employment relationships. The Federal Trade Commission has been active in healthcare in the antitrust areas where healthcare entities join together to push out competition or to negotiate more aggressively against payers. They've been active in those areas, but they have not been active in employment generally or in healthcare employment. They are a federal commission created by Congress to pursue consumer protection and unfair competition initiatives. Things like antitrust, when companies get too big and control too much of the market share, that's a Federal Trade Commission sort of issue. Unfair competition is broader than that, and obviously they claim it's broad enough to include non-compete clauses. There are 5 commissioners. By statute, there can be no more than 3 of the 5 from the same political party. The current chair is Lena Khan, and to say Lena is a true believer in the Federal Trade Commission's charter would be an understatement. In her official biographical write-up on the FTC website, I picked out this quote that says she's focused on exercising the full suite of the FTC's statutory authorities. So when an appointed non-elected chairman of a bureaucratic agency says that that's their goal, I think it bears paying attention to. So Mark, I'll turn it over to you.
Sure. So I'm going to cover some of the basics of this non-compete rule that was just published by the FTC. And I want to say, just as a caveat to all of this, we really are not addressing in this webinar, because it's beyond the scope, all of the various state laws that apply to non-competes. We'll talk a little bit about the interplay between this new rule and the non-competes, but for those of you who have non-competes and you operate in various states, please don't forget to review state laws, which have been changing significantly within the past 2, 3, 4 years. So with respect to the FTC rule in particular, it goes into effect September 4th, 2024, unless a court intervenes, and we'll talk a little bit more about that later. But that's the effective date, 120 days after it was published in the Federal Register. And it basically says it's an unfair method of competition to enter into or attempt to enter into a non-compete clause. In other words, so not just having someone sign one of these, but even asking an employee to sign one of these is an unfair method of competition and prohibited by this rule. Enforcing or attempting to enforce a non-compete clause. So again, that would include things like a cease and desist letter, or even potentially just telling an employee, hey, keep in mind, you can't compete with us after your employment ends. That arguably is an attempt to enforce a non-compete clause. Even representing that a worker is subject to a non-compete clause that is otherwise prohibited by this rule is in and of itself inappropriate and considered an unfair method of competition. So as you can see, very broad in terms of what the FTC considers to be unfair competition. Brad, if we can, oh, thank you. So the question is, well, what's a non-compete? And the FTC defined this pretty broadly. Again, this is not a narrow rule by any stretch. It's any term or condition of employment by policy or agreement. So it's not even necessarily an agreement. If there's just a policy you have in place, that could be enough. And that prohibits, penalizes, or functions to prevent a worker from seeking or accepting any work after employment or operating a business after employment. So those are, again, those are very broad. A couple of key points to keep in mind here is that when it talks about this prohibition being a term or condition of employment, the question that arises is, well, what happens when someone is leaving or has just left employment? And you try to insert a non-compete as part of a severance agreement, for example. Is that going to be prohibited? My hunch is the FTC would say yes, even though it doesn't appear to fit within the ambit of the rule. But that's going to be something that is going to have to be worked out. The other thing to keep in mind is this rule is really focused on post-employment or post-relationship activities. This is not saying that you can't prevent someone from competing during their employment or during their relationship with the entity. It's focused on after the employment or other relationship ends, but it's pretty broad when you look at what they can and can't do after the relationship ends.
And Mark, I'd like to focus on that last part that says functions to prevent a worker from seeking other employment or operating a business after their employment. Because the FTC went to some great lengths in the commentary that they published along with the new rule to explain that employers can try lots of different ways that are not strictly a non-compete clause to prevent competition by former employees. You can have overly broad non-disclosure agreements, NDAs, that make it impossible or severely restrict the employee's ability to compete in the same market because of some effort to limit the employee's ability to do business in the same business. You can have these excessive training repayment agreements where they essentially tie the employee's hands, because if they left the employment they're in today, they would have to repay such an amount that they're effectively prevented from going to work for a competitor. Liquidated damages clauses in employment agreements saying that if you do go to work for a competitor, you agree to pay us X amount of dollars. And severance agreements with forfeiture provisions were specifically noted in the commentary, saying that you can't condition a severance payment on the agreement not to go to work for a competitor, or condition a portion of the severance payment on that condition. And then non-solicitation provisions, which we'll come back to in a while, those cannot be overly restrictive. The rule doesn't completely prohibit an agreement not to solicit current patients or current clients, but it says those cannot be overly restrictive. So there is some, you have to think about the kinds of things that are prohibited by this rule more broadly than just direct, you shall not compete clauses. It can go well beyond that.
So the question is, who's covered by this rule? And the answer again is lots of folks. It's including not just your employees, independent contractors, interns, externs. I would say if you have non-competes with an intern or extern, that's probably a separate issue, regardless of this rule, that is worth looking into. But it's just important to remember that this rule really is broad, and it's not just employees, it's any worker. So just keep in mind, for example, if you have, physician employees, they're going to be covered by this rule. And there are very limited exceptions, and we'll talk about those in a minute, but it doesn't matter whether they're paid or unpaid or what their title is.
So just to hammer home the breadth of what this rule does, I mean, this rule effectively invalidates enforced in it effectively invalidates current contracts, current contractual terms. Not only does it invalidate those current contractual terms, it requires you to give notice to anyone who may be subject to one of those contractual terms. So every employer who has attempted to use a non-compete, whether by contract or by policy, must give notice to current and former employees, current and former workers, which is broader than employees, that the non-compete clause is now unenforceable and will not be enforced. That notice has to be given by September 4th, which is the effective date. The rule itself includes a model notice. You don't have to stick to that model notice, but it's probably the safest course of action to do so. You have to hand deliver, mail it to a personal street address, email it, text message. Those are all approved methods of communication. And obviously you have to identify who the employer is, who the entity is that claims that they have the non-compete. So not only are these invalid, but you have to tell everybody they're invalid, and do so by in written form.
And I see we got a question, aren't senior executives excluded from these provisions? Very timely, given our next slides. There is an exception for senior executives, but as we'll talk about, it's not quite as good as one might hope. Number one, it's pretty narrow. So it's limited to those who hold a policy-making position. And the FTC made it clear it can't be an officer of, for example, a subsidiary or affiliate unless they have policy-making authority for the parent entity. So you have to have policy-making authority, I'm sorry, final policy-making authority with respect to significant aspects of the business, not just advising or influencing policy. That's pretty vague. It's going to take some time probably to figure that out. And I see at least one person is having problems seeing the slides. If others are, hopefully we'll be able to resolve that with Luke, but hopefully folks can see the slides. The senior executive exception really does apply again to limited positions. And again, the FTC rule provides some examples here. President, vice president, treasurer, folks in those higher roles with annual compensation above $151,164, not including benefits. So you wouldn't include, for example, how much the organization pays for health insurance for the executive. And if we could go to the next slide, Brad. So here's kind of a catch with respect to the senior executive exception, beyond the fact that it's very narrow. It applies to existing non-competes. So existing non-competes remain enforceable, but even with senior executives, you can't have new non-competes after the rule's effective date on September 4th, 2024. So it's it's not not the exception I think a lot of people had hoped for. And if you know, after 9/4/2024, you really can't enter into or enforce these non-competes. So it's a very narrow exception. And I see we have another question asking whether physician owners who are all officers of the practice and hold official titles, president, CEO, treasurer, would this apply to them? The answer is maybe. I think there's a pretty good argument that yes, it would. The only reason I hedge a bit is because I've seen situations with physician owners where they say, well, I had the title, but I had no policy-making authority. I wasn't on any committees. I didn't even really participate in any votes or things like that. So, technically, should that apply? Should the exemption apply to them? Maybe, but I wouldn't say it's a guarantee if you have, especially in a larger organization where someone might have a title, but they're not as involved in any policy making. Brad, do you have anything to add on that?
Yeah, I agree. I think it's that policy-making authority that's also required to apply the exception that will trip up the idea that every physician owner is going to be subject to the senior executive exception. I don't think just the fact that they're a physician owner of a practice is going to satisfy this exception. I think it's going to require more than that. And obviously, for the many hospitals out there who have non-competes with their physicians because you're paying them huge sign-on bonuses and you're paying them, student loan recoupment bonuses, none of that is going to satisfy the senior executive exception for employed physicians. They're just not going to be covered by this exception unless they have some other office that gives them that final policy-making authority. So perhaps your medical director, your chief medical officer might qualify, but below that, where you're going to have a problem with this. So let me talk about what entities are covered, and we're getting some other questions that are pretty specific and pretty detailed. We'll try to get back to those. One question that probably makes sense to cover right here is that there's a comment that the FTC wants to make non-competes fade away as employees leave and new ones cannot be signed. Absolutely, that's what they want to do. And to the extent your contracts are terminate as a matter of term at a particular date and then have to be renegotiated and amended, you can't enter into a new contract. So not only when people leave, but when people's contracts come up for renegotiation, this becomes an issue. So you're going to have to be careful with that process as well for those folks that are under what I would call grandfathered non-compete clauses. So what entities are covered? The rule is very broad and, in my opinion, ambiguous in its definition. It speaks in terms of person, meaning any natural person, partnership, corporation, association, or other legal entity within the FTC's jurisdiction, including any person acting under color or authority of state law. And the FTC, there are lots and lots of comments tried to persuade the FTC to be more specific, to narrow that definition, to give some very precise examples, or these are in and these are out. And the FTC just doggedly refused to do it and said, we're exercising our jurisdiction under this rule to the greatest extent of our jurisdiction under the Federal Trade Commission Act. So in other words, every ounce of power we have will be used to enforce this law against any entity that we can demonstrate is covered by our jurisdiction. So nonprofits, there are, I'm sure there are folks out there who are part of nonprofit entities. There is no exclusion from this rule for nonprofit entities, generally speaking. Now, the FTC Act has some limits on its own application to nonprofit organizations. It defines corporations to be covered if they're organized to carry on business for its own profit or for that of its members. So if you are a pure nonprofit in the pure sense of the word, you are probably excluded from this rule. But if you are a nonprofit association, for instance, you're a hospital association perhaps, or you're some other sort of association, and you provide substantial economic benefits to your for-profit members, then under Supreme Court authority, the FTC Act applies to you. So there's no blanket nonprofit rule, and we'll have to determine on a case-by-case basis whether a particular nonprofit is going to be subject to this rule. Many of you, I think, will be if you are in the kind of pure nonprofit, serve the public sector. But for those of you that have for-profit affiliates and are in the business of providing service to for-profit entities, for-profit members, we're going to have to look at that more carefully and see what kind of arguments we can make on your behalf. The two-part test for nonprofit coverage is there a nexus between the organization's activities and its public, or in other words, its nonprofit purpose, and are the proceeds, the revenues, properly devoted to public rather than private interests? So that's kind of the test of purity for nonprofit coverage under the FTC Act. If you can meet those two prongs, then you have a good argument that you're not covered by the FTC Act and therefore not covered by this rule. A couple of examples from some FTC enforcement actions and case law. The FTC was allowed to exercise jurisdiction. Now, this is not the non-compete rule. This is some of their broader anti-competitive powers. The FTC did exercise jurisdiction over a nonprofit entity that consisted of a nonprofit hospital and a 100 physician group. The physicians and the hospital were part of another nonprofit entity, and the nonprofit entity negotiated with payers for the for-profit physician practices. In other words, they got together and they negotiated with insurance companies on the pricing that they would be willing to accept, and they controlled a huge portion of the market within a geographic region. And the FTC was able to say that nonprofit entity is subject to FTC Act jurisdiction because they were acting on behalf of their for-profit physician practices. So when a for-profit affiliate or a for-profit group controls a nonprofit entity, that's when you're going to see that nonprofit protection fall away, and the FTC may be trying to enforce this rule. Public entities are another very vague and ambiguous area in here. There's no specific exclusion in the rule for public entities, and the FTC again declined to clarify when public entities would be subject to the jurisdiction. They did say that some public hospitals will be subject to this rule, but they wouldn't really discuss in more detail what factors they would look at to determine whether public hospitals would be subject to the rule. They referred to what's called the state action doctrine. The state action doctrine is an old doctrine developed by the US Supreme Court that recognized that states are sovereign entities, and states can do things within their state, and they can authorize political subdivisions within their state to do things that may be anti-competitive. For example, the state statute can authorize a county to be the only water and sewer provider in that county. Even if there are private entities that want to be the water and sewer provider for the county. States can do that. They can authorize a county to decide they're going to have their own water and sewer department. So the state action doctrine in some states may protect county hospitals, memorial hospitals, hospital districts, may give those districts some authority to engage in anti-competitive things that would not be permissible if they were a private sector hospital. There is a lot of room for uncertainty in how the state action doctrine will apply to non-competes. The law just hasn't developed in that direction at all. And obviously it wouldn't have, because the state action doctrine would not have had any cases arise to deal with non-competes yet. So there's a bunch of uncertainty here on when public hospitals will be able to meet this state action doctrine. Every situation is going to be fact intensive and very unique. So it's really difficult to predict based on what the law is today, how the law is going to apply as we go forward in this setting. Mark?
Yeah, and let me address a few of the questions that have come in, because they tend to raise similar issues about whether this rule is going to apply in certain circumstances. One question is whether or not this rule is going to bar no hire provisions that may exist in agreements between two entities. So it's not directly with a worker, for example, but maybe an entity is agreeing to staff a particular department or emergency room or something like that, and the other entity agrees not to hire those folks. I think an argument can be made. I'm interested in Brad's thought, but my view would be that probably doesn't meet the definition under the rule of a non-compete, because it's not entered into as a term or condition of employment. That said, I would be concerned, number one, I'm always concerned with no hire provisions, just generally to ensure that they don't raise any antitrust concerns. And they're fine in a lot of cases, but I would just be cautious about that. And number two, even if they're not barred by this particular rule expressly, you still may have issues under state law with respect to enforcing a no hire provision. And I could certainly see someone who is impacted by a no hire provision trying to challenge that provision by citing this new rule. Brad, any additional or different thoughts on that?
Yeah, I could certainly see that, because an employee who's prevented from going to work for one of the entities that's subject to the no hire provision could argue that the entity has adopted a policy of not permitting me to accept employment or to pursue employment with that entity. That policy is based not on any agreement with me, but that policy is based on their separate contract with my prior employer, the staffing agency, who now says I can't come to work for you. That's a policy consideration between the employer I want to go to work for, the hospital, and the staffing agency that the hospital agreed to contract with. So I could certainly see an argument based on that policy language in the definition of a non-compete where that could happen. So yeah, I mean, I think that's clearly a risk. There's another question about two or three questions. I'll kind of roll them all together. Contracts that auto renew. I think contracts that auto renew are probably going to be safe if they're with senior executives, are going to be safe from the enforcement of the senior executive, or I should say they'll be safe within the senior executive exception, as long as the person with the contract meets all the other requirements of the senior executive exception. Final policy-making authority makes over $155,000 and change per year. So those are also all going to continue to be requirements, even if even if the non-compete is currently in effect in a contract that auto renews. For everybody else, auto renewal is meaningless. The contract is void if the rule is enforceable and survives judicial scrutiny. Same for physicians. Does not matter how much money you pay a physician to come to work for you. It does not matter if they make $800,000 a year and you paid them $200,000 in incentives, provided that's fair market value, of course, if they are not in a final policy-making position. If they're not in a final policy-making position, whatever non-compete you have with them will be unenforceable if this rule remains enforceable after judicial review.
Thanks, Brad. And one other thing to keep in mind, if you end up amending an agreement with a senior executive, after September 4th, I'd be very concerned. I don't think the rule expressly deals with that, but I think there's a good chance that either the individual or the FTC would say, well, you may have entered into the original agreement before September 4th, but you amended it and thereby entered into essentially a new agreement, an amended agreement as of September 5th or whatever it is. So I would be cautious about amending agreements with senior executives who have, who otherwise meet that exemption, because you may end up putting at risk the ability to continue to enforce that under this senior executive exception. Some other exceptions to keep in mind, the FTC did carve out the sale of a business entity or a person's ownership interest in an entity. And interestingly, there's no provision in the rule that requires a threshold ownership interest. So in other words, even a minority owner could fall within this exception. Causes of action based on non-competes arising before the effective date, those are still carved out. And then if you have a good faith belief that the rule does not apply to your entity, I would say I'd be very cautious before relying on that last category, because I think that is going to be very narrowly construed. And my hunch is the FTC and or the courts looking at that would say, in light of the rule, you did not have a good faith belief in most circumstances, even though there's a fair amount of gray, as Brad talked about. I would just be very concerned about relying on that particular exception. In terms of enforcement, according to the FTC, all of these non-competes that don't meet an exception, which is the vast majority of non-competes, are invalid. And the FTC can initiate an administrative investigation. There could be a complaint and a hearing, and of course penalties. And all the things that go along with agency enforcement could happen here if this FTC rule goes into effect on September 4th. The thing to keep in mind is that, well, a couple things to keep in mind. One, the FTC, like any agency, has limited resources, right? And the impact of this rule is going to be incredibly broad, as we've talked about. So the idea that the FTC could really investigate and enforce every single alleged violation, it just couldn't possibly do it, assuming that there are a large number of individuals or groups or others who file complaints, which I think would be the case. It would be surprising if that wasn't the case. that doesn't mean, and I'm not suggesting that, well, there's very little likelihood that you'll face an FTC enforcement action, so don't worry about it. Definitely not what I'm suggesting, because even if the FTC did not investigate, initiate a hearing, or assess penalties, you still have the potential that you are providing consideration, a bonus, equity, something to someone, and you're doing it in exchange for their agreement not to compete with you. And I think there's a strong likelihood that what they're going to do is they're going to file an action in state court saying this agreement is not effective, it's void under this rule. And the end result of that is you will have hired someone, offered consideration, offered something to someone, uh, and they likely have already obtained the benefit of that, but you will not, as an organization, be able to enforce the obligations or restrictions involved. So just be aware that that is a potential issue for you if you're entering into agreements that violate this or do not comply with this FTC rule. It really goes beyond the FTC. And of course, if you do happen to get caught up with an FTC administrative investigation and or hearing, that in and of itself can be costly, time consuming, distracting, and from a public relations standpoint, that's not always what you want to have happen, because that could end up easily becoming public. So I would just be aware that the enforcement of this rule could end up going beyond the FTC, and again, state laws are beyond the scope of this webinar, but just a reminder, certain states, Colorado included, have criminal penalties for violating the non-compete statutes. I have never seen Colorado enforce a criminal penalty. I think prosecutors have bigger and better things to do, but just be aware, Colorado, California, a number of states also have penalty provisions for enforcing or attempting to enforce an agreement that violates state law, even if this law doesn't go into effect or preempt that state law.
So Mark, what's next? Obviously a lot of uncertainty. What are you telling your clients about how to manage that uncertainty?
Well, that's a great question. I mean, the biggest uncertainty right now is this law even going to go into effect? As many of you probably know, the law was challenged almost immediately. I should say not the law, the rule was challenged almost immediately with multiple lawsuits, including in the Northern District of Texas, which is very favored for folks who are challenging federal rules and regulations. The My understanding is the group that filed first, they're kind of in the position to really move forward, but the Chamber of Commerce has moved to intervene in that lawsuit, which probably, if it hasn't been allowed yet, will be. And what I've been telling clients is I would wait for at least another week or two before you start changing your policies or practices, because I think there is at least a decent chance that this new rule is going to be enjoined. In other words, prohibited from going into effect on September 4th. It may take more than another 2 to 3 weeks to figure that out. I think if we're 30 days out and we don't yet have a ruling from the court, people are really going to have to start looking seriously about implementing some changes. But I would be I would be cautious before making a bunch of changes now based on the rule in light of these court challenges. And, you know, it's possible that the rule is upheld. I think it's more likely that the rule is going to be put on hold, and then it will have to be litigated in the district court, potentially appealed up to the Fifth Circuit Court of Appeals, and then potentially the US Supreme Court. All of that takes time. There's no way that is all happening before September 4th. But if the district court doesn't act to put the law on hold, then, you know, again, my view is if we're 30 days out, you know, people need to, organizations should really start thinking carefully about planning for this and being in a position to comply. And it doesn't mean you can't start planning now. I'm not suggesting that, but I think we do have a little time. Brad, what about you? What have you been telling clients?
Yeah, I agree. I've been telling clients to sit tight and wait and see how the court challenges go forth. I think getting ahead of this too far is just a recipe for confusion in your workforce. I'd come back to this topic. I'd try to enjoy your summer and come back to this topic on August 1st and, you know, and see where we are on August 1st. Nothing in this rule, even if it goes into effect, is required until September 4th. So I would come back to it on August 1st if it, you know, and see where we are at that point, get advice from your counsel at that point and figure out whether you should begin preparing to send out this notice, which is the thing that supposedly is supposed to be done by September 4th. The other thing I would do, again, waiting for that September 4th deadline or that timeframe, is think about how to improve your confidential information policies and your non-disclosure agreements. Depending on what kind of, obviously, a lot of you have patient confidential information, which is the trouble is it's confidential by HIPAA, but it's not confidential for continuity of care purposes. So, you know, there's some exceptions to HIPAA that may allow somebody to go to another practice and continue and require that information to be transferred to them. So we need to think about how can we change our confidential information policies and non-disclosure agreements to perhaps enhance our protection under those policies and agreements in the event we cannot prohibit competition directly. Also, we should consider non-solicitation agreements. The commentary with the rule specifically says that it does not prohibit non-solicitation agreements. And non-solicitation agreements are those agreements that say you cannot solicit your current patients to go with you or to join you in your next practice after you leave here. It's not a non-compete. It doesn't prohibit the employee from actually competing in the same geographic area. It limits how the employee can reach out to their former patients. These are very complicated agreements. They can be very complicated because you have to define what it means to solicit. You have to be very precise about what that word means in the context of the agreement. But I would think about whether you'd be better off trying to institute a non-solicitation agreement if the rule goes into effect. What do you think about that, Mark?
Yeah, I completely agree with that. The one caveat I would say is, especially for physicians, there are oftentimes rules or guidelines that impact restrictive covenants with physicians in particular at a state level, including ensuring that a physician's patients know where the physician is going. So just be sure to check applicable state law or rules that might apply with respect to physician non-solicits, but otherwise I completely agree with that advice.
That's other questions, but I think we have some time to deal with that. Question about, does the FTC legally have the authority to promote this rule? Great question. The challenges that have been brought so far have included challenges based on what's called the major questions doctrine. which is the doctrine of law that says that an agency, an administrative agency, can't just decide the breadth of their authority. It has to be based on the statutory authority that they've been given. If you recall back in the awful vaccine mandate days, OSHA tried to dictate a vaccine mandate for any employer. I don't remember the number of employees, but any employer with more than 100 employees, I think. And the Supreme Court said, no, that's invalid under the major questions doctrine, because OSHA has never been authorized to impose healthcare requirements on a huge majority of the people in the nation. Will this rule suffer the same result? I don't know, but that'll be front and center in all the litigation that's going to go forward about whether this rule is valid or not. There's some questions about what about an agreement requiring a specific amount of time? I take it that means time in a non-competitive setting or recoupment of a bonus. I think it really is going to depend on the terms of that sort of a recoupment provision. The rule prohibits any term that penalizes a former employee for taking other employment, any other employment. And so to define what penalizes the employee, you have to kind of look at what's the recoupment going to look like? How large a recoupment is it compared to their overall compensation? Probably there's got to be some relationship to the potential loss to the employer. The commentary is pretty mushy about what that penalizing aspect will look like, and I'm sure it's going to be largely a case-by-case basis. But there is no sort of blanket way to say that anytime you have a bonus with a recoupment provision, that will not be a penalty that amounts to a functional non-compete. Those are going to be litigated issues that come up under this rule when you have to turn around and litigate against the FTC, or you have to litigate the issue in a non-compete lawsuit against the physician when the physician is saying this rule makes your non-compete and your recoupment illegal.
I think another question is, well, what happens if you have a contract with a non-compete that's void? Is the entire contract void? Do you have to redo the entire contract? And it's a good question. I think generally my view would be that the non-compete portion is void, not the entire contract. And typically contracts have what we call severability provisions. That mean if there's a void or unenforceable portion of the contract, then the remainder of the contract is still enforceable. But that really highlights the major impact of this rule. What the FTC has done has said, not just on a prospective basis, but on a retroactive basis, this portion of the contracts you have entered into are void. And as I mentioned earlier, what that means is you may have hired someone, provided a bonus or other consideration in exchange for these restrictive covenants, and now you can't enforce them. So you may be in a position where you want to renegotiate. As Brad and I talked about earlier, I don't think I would try to reopen or renegotiate contracts until we have a little better idea about what's going to happen with this rule. But it's a really unusual thing to have an agency invalidate contracts across the board, or at least portions of contracts where someone has already really gotten the benefit. And a similar question was posed about, well, what about if you hire a physician, you set them up, provide them with a panel of patients, and they decide to leave and the patients just follow them? And the answer, unfortunately, is unless they fit within an exception to the rule, their non-compete is going to be invalid. So that again goes to just how sweeping and impactful this rule is going to be for healthcare entities and others. Because the organization may have said, well, the only reason we're willing to do this and to set you up is because we know we're going to obtain a longer term benefit from this. And that bargain is being just completely demolished by this rule. So it really is, it's not just changing the way in which people are going to be entering into contracts prospectively, but it really is going to force everyone to look at what are we going to do with our existing agreements and how are we going to ensure that we're protected if this rule goes into effect. And I have, for what it's worth, I've seen some commentary talking about so-called garden leave provisions, where someone remains an employee for a period of time. They're not working, but they continue to be paid as an employee. Very common in the UK and abroad, not quite so common here in the US, but some states have enforced so-called garden leave provisions. The concern I have about, though, relying on a garden leave provision is how do you enforce it? I mean, it's just, trying to enforce that type of provision. If they breach it and they say, well, okay, I don't want to remain an employee anymore. You don't have to pay me. I'm just going to go compete. Oh, okay. I mean, now you're in the situation where now they're a former employee. And so now you have a problem. And just keeping someone on the payroll can often lead to side issues, such as trying to maintain their benefits, which oftentimes you can't because they're not an active employee and they're not on an FMLA leave. And so there are just collateral issues to consider. But the biggest one is there's just no teeth, in my view, to that type of provision. So it's really going to be looking at things on the front end and figuring out how do we deal with the situation where we can set someone up and they could literally, form all these relationships, do all these things, and according to the FTC, there is literally nothing we can do to prevent them from taking these clients, other than potentially a non-solicitation type of provision, which again could be complicated under state law or rules.
Yeah, that is the ugliest outcome for many of our healthcare clients with this rule if it goes into effect. And we can't predict the future, but hopefully the legal challenges will be successful and we'll be dealing with a rule that is then invalidated or remains tied up in litigation to such an extent that it ends up timing out, if you will, with a change of administration or something like that. So, well, I don't see any other questions. We greatly appreciate your attention and your attendance today. Mark and I will be here in August when you're ready to start paying attention to this topic again. And we'll do our best to keep you updated on the judicial challenges, particularly when there are significant developments through our employer's lawyer blog. If you're not signed up for that, drop me an email. I can make sure you get the opportunity to be on the mailing list for that. So again, thank you. We'll sign off.
Thanks, everyone.